At a general court-martial, you have a right to go through an Article 32 hearing. An Article 32 hearing is the prelim, as we would know it in state court. An Article 32 hearing, no case can get referred to a general court-martial unless there's a Article 32 hearing. And what an Article 32 hearing is, a preliminary hearing officer, also known as a PHO, is appointed. That is a judge advocate, typically in the rank of 04 or higher, and they are supposed to be neutral and detached to hear all of the evidence that the government wants to present that goes to probable cause. So they listen to the evidence that the government's going to present. That can be witness testimony, that can be declarations. But typically what that is the government just puts in the ROI, or the report of investigation, and gives them the bare minimum necessary to show probable cause, which is, again, a low standard. And at the Article 32, you have the right to be at the Article 32. You have a right to testify at the Article 32. Although I've yet to this day, I have not seen a scenario where it made sense to have an accused testify at an Article 32. It's still a right you have. You have a right to call witnesses at the Article 32, to request evidence. There's subpoena power. So there's a lot that can be done at the Article 32 to shape the trial. And what I see most often is a lot of lawyers just waive the Article 32. And there is a time and a place to waive an Article 32 hearing, which you can. But before you waive an Article 32 hearing, make sure you understand why you're waiving it and if there's a strategic decision to waive it or not. Typically, I find that there's not a good strategic decision to waive it, although I've waived Article 32s before as well, but there has to be a good reason to do so. And Article 32 can be very useful if you have a case that's on the fringe. What I mean by that is there's a case where the evidence isn't very strong. There's not a lot of corroboration to the claims. Maybe there is a very weak he said, she said case, or maybe there is a, whatever case you have, which is maybe there's a lot of very weak evidence and we don't believe the government's going to be able to prove the charges beyond a reasonable doubt. We may make a very big showing at the Article 32 with the goal of the preliminary hearing officer making a recommendation up to the convening authority to withdraw and dismiss the charges, or to send it to a lower form. And that could be, again, that could be an Article 15, or maybe even send it to a GOMA, or there's other things that can happen as opposed to going to a general court-martial. And so if that's the case, there may be a strategic reason to do so. And a preliminary hearing officer will be required to write a written report. And again, it's a recommendation and it's non-binding. So we've had cases where a preliminary hearing officer has heard essentially our side of the story, or our case at the Article 32, drafted a compelling report for the charges to not go forward, but the convening authority just did what the hell they wanted to do and sent them to trial anyways. That's a reality that you have to just be able to deal with. But we've had other cases where we've had a very favorable report, and the convening authority or the commanding general looks at that report and either withdraws and dismisses charges. Certain charges are not referred, and we've even had cases that never made it beyond to the Article 32 because of the work we did at the Article 32 hearing. One case in particular we had an aggravated assault case where we had a clear issue of self-defense. We were able to get the video from the bar in question. This was a one down in the set out in Korea. We were able to get the video, which very clearly showed that our client was acting in self-defense. We presented that at the Article 32 because OSI didn't bother to get the video, which is kind of extraordinary on its own. That video was shown to the commanding general. The commanding general withdrew and dismissed all of the charges. Our client never had to go through a trial. He was a pilot and was, again, flying. Within a month of that occurring, all the charges were dropped, and he was going and fighting and doing what has been paid a lot of money to do, was to fly fighter jets. And so that's a good example of why a 32 is critically important, and you need to be very mindful if you're going to make the decision to waive it. Again, make sure the decision to waive an Article 32 is not because your lawyer is being lazy or is too busy and doesn't want to do it. That's critically important.